Okay, let's get into this one. You've got all the makings of a classic neighborhood showdown. A leaky roof, a totally fed-up new homeowner, and a homeowners association basically saying, not our problem. But, this story has a twist that really shines a light on where the blame for a home's problems can sometimes hide.
I mean, it's the ultimate homeowner nightmare, isn't it? Just imagine. You've finally moved into your new place, you're surrounded by boxes, and then, bam, you find it. A serious, super expensive problem that the seller somehow forgot to mention. So who's on the hook for that bill? You? The seller? Or, like in this story, maybe the HOA? Well, that exact nightmare became a reality for Carla Snyder. Right after moving into her new villa, she stumbled upon some major water damage and even mold. Oof. What looked like her dream home was hiding a very damp and very, very costly secret. And the price tag to fix this hidden disaster was not small. We're talking $11,476. This wasn't just some little inconvenience. It was a huge financial hit. So Carla decided to fight back. She was convinced the whole problem started with a faulty roof, and that's something the HOA is supposed to maintain, right? So Carla Snyder filed a formal dispute. She was taking her Homeowners Association to court, kicking off a major battle of documents, expert witnesses, and two very different stories. So here's the legal breakdown. On one side, you've got the petitioner, Carla Snyder. On the other, the respondent, her HOA. Her claim seems pretty simple. She's arguing that the HOA violated Section 14.2 of the community rules, the part that she believes makes them totally responsible for the roof and any damage it causes. And let me tell you, Carla built what looked like a really strong case. She didn't just show up and point fingers, she came armed with expert testimony to prove the HOA had been negligent. And here it is, the core of her argument, straight from her expert witness, the contractor who actually did the repairs. He testified that the root cause of the whole mess was missing roof flashing, and he called it a design flaw. That's a really powerful statement in a case like this.
So what the heck is flashing, anyway? Just think of it like a raincoat for the most vulnerable spots on your roof, the joints and edges. It's a totally standard, absolutely essential part that's supposed to direct water away from the house. And according to Carla's expert, it just wasn't there.
So let's just break down her logic. She's saying, 1. The rules put the HOA in charge of the roof. 2. The damage came from missing flashing on that roof. 3. That's a construction defect. Her conclusion? It seems pretty straightforward. The HOA was negligent and they owe her the money. Sounds airtight, right?
Well, not so fast. This was definitely not an open and shut case. The Hadas Villas Association fired back with its own evidence, pointing to a completely different part of the community documents and a very different version of events.
And right here, we see the legal tug-of-war in action. While Carla was zeroed in on Rule 14.2 about roofs, the HOA pointed to Rule 14.1. Now, this section makes the owner responsible for their own unit and, this is crucial, for exclusive use areas like patios and balconies. Their whole defense was that the problem didn't actually start with the roof at all.
To back this up, the HOA presented their own evidence, basically a log of all the roof maintenance. This timeline shows that, far from being neglected, the roof had major repairs back in 2015, including new flashing. Then when Carla complained in 2019, another inspection found no current problems, calling the leak an old issue. This totally challenges her claim of a flawed, neglected roof.
And this is where the whole case takes a sharp, unexpected turn. The investigation dug up a critical piece of the home's history, shifting the blame away from the HOA and squarely onto the person who sold the house to Carla in the first place.
The property manager testified that this wasn't a new problem. No way. The previous owner had the exact same issue with water damage. But here's the key. The damage was coming from the pergola on the patio. And remember Section 14.1? The patio is an exclusive use area, which means it's the homeowner's responsibility.
And here it is, the smoking gun. This is a sworn statement from the contractor the previous owner hired. He admits the owner knew there was rotted wood under the stucco, but chose not to fix it properly. Instead, he told the contractor to just do a patch job, to basically just cover up the rot. Unbelievable.
This move wasn't just a cheap fix. It was a cover-up with real legal consequences. See, under Arizona law, sellers are required to disclose all important material facts about a property. The seller knew about the rot,
knew about the shoddy repair, but on the official disclosure form he gave to Carla, nothing. Not a word. A complete failure to disclose. So with all the evidence on the table, the conflicting rules, the maintenance records, and this huge secret from the previous owner, the administrative law judge had to make a decision. The judge's logic really just followed the evidence step by step. The leak started at the pergola. The pergola is an exclusive use area, which falls on the owner thanks to Rule 14.1. At the same time, the HOA proved they did do their job maintaining the roof. So the conclusion was pretty clear. The HOA hadn't actually violated any rules. And so the final verdict came down, clear and simple. Carla Snyder's case against her HOA was dismissed. She was still out that 11 grand, and the HOA was found not to be at fault. You know, this case is so much more than just a dispute between one owner and her HOA. It's packed with some critical, hard-earned lessons for anyone who owns a home or is even just thinking about buying one. So what can we all learn from this? Well, first, you have to actually read your community documents, your CC&Rs, so you know where your responsibility ends and the HOA's begins. Second, due diligence is everything. You just can't blindly trust a seller's disclosure form. Third, always remember that the problems you find in a new home might trace back to something a previous owner did. And finally, documentation wins arguments. The HOA's meticulous records were absolutely their best defense. It really leaves you with a final thought to chew on. A home isn't just drywall and pipes. It has a history. And as Carla Snyder learned the hard way, sometimes you're not just buying a property, you're inheriting the consequences of all its hidden secrets.